B'Shem Adonai Naaseh v'Nasliach, we begin Masechet Horayot. The subject of this Masechet is what happens if a Bet Din makes a mistake and issues a ruling, and people follow that ruling. Who is responsible to bring a Korban Hatat? This is the subject of a paragraph in Vayikra chapter 4, Pasuk 13, reads, V'im kol adat Yisrael yishku v'ne'alam davar me'aneh hakahal. If the community leadership of Israel has erred, in Hebrew it's kol adat Yisrael, it sounds like everybody made a mistake. So how could everybody make a mistake? They all made the same sin at the same time? It means because there's something that went unnoticed by the eyes of the community, meaning the leadership, the Supreme Court judges ruled a mistaken ruling, and people followed it. And they followed one of the mitzvot. We're talking about a mitzvot lo ta'aseh, for which one has to bring a korban hatat. If it's an individual who forgot and mistakenly violated that, they will bring korban hatat, and later on in this perek says they will bring a small animal, a sa'ir. But if it's because of the judges that the people follow, and there is guilt, so who's responsible? In that case, the community together will bring a par, a bull, as a chatat offering, so a large animal. And who brings it? It's the elders of the community will put their hands on it to do semicha v'shachat et hapar lifnei Adonai. And so, because the heads of the community, the judges, were the ones that issued the wrong ruling, they are responsible to bring the korban chatat, and the individuals who followed their ruling are not liable. And that's the subject of this Mishnah here. Horu bet din la'avod al achat mikol mitzvot hamurot b'Torah. If the bet din issued a ruling to violate one of the mitzvot of the Torah, it's not, in fact, any mitzvah. It's not talking about if it's a monetary or capital punishment, but rather specifically a lav, for which one has to bring a korban chatat. It still uses the word mikol mitzvot hamurot because that's from the language of the pasuk itself here, mikol mitzvot Hashem. Then vehalach hayachid v'asa shogeg al pihem, and an individual unknowingly, and not a very learned individual, someone who trusts the bet din, goes ahead and mistakenly follows their ruling. Let's say, for example, they rule that a certain type of fat is permitted, but meanwhile, it's actually chelev, it's actually prohibited fat. But they say, this is kosher. Ben she'asu ve'asa imahen, ben she'asu ve'asa acharehen, ben she'lo asu ve'asa patur mipnei shetala bebet din. In any of these three scenarios, it doesn't matter whether the judges themselves violated. In the case of forbidden fat, they ate the forbidden fat, and they're following their own ruling, and the individual also did it together with them. Or, a second case, whether the judges violated first and ate it, and then the individual later on ate it, or whether the judges did not violate at all. They didn't eat it at all, but they issued a ruling that is kosher, and then the individual ate it. In all these cases, the individual is not liable because he relied on the ruling of the bet din. It brings these three cases because each one builds on the next one and gives a bigger chidush. Not only if they also were doing it, or they did it first, where the individual's following them, that the individual's patur, even if the judges themselves did not violate. They just issued the ruling, and only the individual sinned. Even so, the individual's patur. You might have thought that when the bet din themselves do not sin, so maybe in that case they don't bring a korban because they didn't violate, and only an individual violated. Maybe in that case, individual would bring a korban. No, not so. As long as they issued the wrong ruling, whether they themselves violated or not, doesn't matter. The individual is patur. Next case, horu bet din ve'yada echad mehen sheta'u o tamid ve'hu ra'ui l'hora'ah. If the bet din issued a ruling that's wrong, again they said a certain piece of chelev is kosher, and one of the judges knew that's a mistake. He knew it. He's on the panel of judges, but he personally knows this is a total mistake. or if there's a student there, not just a low-level student, but a high-level student who is worthy of issuing halachic rulings. He has semicha, so he knows better, and he knows that this is a mistake. But he says, well, I know this is a wrong ruling, I know this is not kosher, but the bet din, the rest of the bet din, the majority rule that is kosher, so he goes and eats it, relying on them. Then it's the law is the opposite. Ben shasu v'asa imahen, ben shasu v'asa acharehen, ben shelo asu v'asa, hareh zeh chayav mipeneh shelo tala bebet din. And here again, the same three scenarios. Whether the judges ate it and the individual also, the individual judge or the individual student, or whether the judges violated and he did it afterwards, or whether the judges themselves did not eat it, only this one judge who knows better or the student that knows better went ahead and ate it, that individual is liable because he did not rely on bet din. He actually knew the bet din was wrong. In the case of the simple individuals, not so learned, so he says, well, the bet din, they must know what the right ruling is. So he is totally reliant on the bet din. But this Talmid, Chacham, knows that it's not kosher, so he is liable himself for eating this item. In this half of the Mishnah, the three cases go from the less obvious to the more obvious. When they violated and he then violates afterwards, then he is liable. So that if he's liable in that case, then all the more so he is liable when the rest of the judges did not violate, and he's the only one that violated. Certainly, he would be liable. What's the general rule? The general rule is that someone who is reliant on himself, he knows better. He can't make an excuse, the bet din said so, because he's a chacham and he knows that this is a mistaken ruling, and he eats it anyway, so he is liable. But if an individual relies on bet din because he's not so learned and he doesn't know better, then the individual is patur. Amar Shemuel, leolam en bet din chayavin ad sheyomru lahem mutarim atem. Shemuel says that the bet din is liable to bring their korban chatat, the par, for forgetting on the communal level. The judges themselves are only liable to bring this par chatat if they say a ruling, mutarim atem, you are permitted. It's not just if they're just talking about it, they actually have to say you are permitted. Rav Dimi min harda amad ad shemru lahem mutarim atem la'asot. Rav Dimi from the Hardak goes a step further. It's not enough that during the course of the deliberation they end up saying it's permitted, because that is still theoretical. In an academic discussion, when they're discussing a halacha in the Bet Midrash, they might say it's permitted. But that's not a halacha lema'aseh. Very often when you're discussing a subject, right, you say, okay, yes, this is permitted. But if an actual case comes along, then you say, wait, that was just in the theoretical discussion. Even if it was the conclusion of that theoretical session, they didn't give it as a ruling that people can actually follow, halacha lema'aseh. So therefore, Rav Dimi Sem and Hada says that the bet din will only be liable if they went and told the public, this is permitted for you to act upon. What's the reason? Because if they didn't say the word la'asot, then the ruling is not complete. Yes, they had a discussion and they came to a provisional conclusion. If they just said mutarim atem, they're saying, yes, it seems that this would be permitted. And a lot of times, poskim will write a teshuvah and they'll write at the end, halacha v'lo lema'aseh. It seems to me that this is the conclusion, this is the halacha, but this should not be used in practice until other people come and discuss it further. And if there's a further agreement by the other sages, right, then it will be halacha lema'aseh. So therefore, if they did not say mutarim atem la'asot, according to Rav Dimi, then they are not liable if someone follows their ruling. They followed only a provisional conclusion, not a final conclusion that should be practiced. Amar Abaye, afananame tanena, chazar le'iro v'shana v'limed kederech shelimed patur, hora la'asot chayav. Abaye says, I have a proof to back up Rav Dimi min harde'ah, that the court has to say a ruling to be in practice, halacha lema'aseh. And this is from a Mishnah in Masechet Sanhedrin regarding a Zaken Mamre. Zaken Mamre is in a way the opposite law of the second paragraph here. The Zaken Mamre is someone who hears what the Bet Din Hagadol says, goes back to his city and rules and makes a ruling against the Bet Din Hagadol. And so there it says, if he goes back to his city and he teaches the same way he taught before he heard from the Bet Din Hagadol, meaning he's teaching his original opinion against what the Bet Din told him, patur, that's okay, because he's teaching theoretically. He's saying, seems to me that the halacha should be like this. That's okay, you can give your opinion. However, if he went back to his town and hora la'asot, he gave a halacha lema'aseh, saying, yes, you can practice this, and he says one thing, and the Sanhedrin said something else, then he is liable. This was in Parashat HaShavua today, and he is liable the death penalty for going against the Bet Din Hagadol. You see from here that he is only liable when the Sanhedrin gives when he gives a ruling halacha lema'aseh. So this is actually a different law. The law in Horayot is the way the opposite. This is a judge or a high-level Talmid who decides to follow the law of the Sanhedrin, but he's not supposed to, because in this case, he knows that it's wrong. So if you know that it's wrong, you cannot go and violate it. Okay, so even though these are on opposite sides, but nevertheless, there's a strong similarity between the two laws. And so he says, just like the Zaken Mamre is only liable when he gives a halacha lema'aseh, so too the members of the Sanhedrin are only liable when they issue a mistaken ruling if they said halacha lema'aseh. Amar Rabbi Abba, af ana nami tanena, horu la bet din lihinaseh v'alcha v'kilkela chayevet bekorban, shelo hitiru la ela lihinaseh. Rabbi Abba says, I have another proof for Rav Dimi's opinion that court is liable only if they say halacha lema'aseh, and this is from a case in Mishnah Masechet Yevamot, where a woman's husband goes away and he doesn't come back. And there is one witness that says, oh, I saw him that he was dead. And the Bet Din said, even though they really need two witnesses generally, they accept it. And they tell her, because they want to do her a favor, because she's not to be an aguna, they say, you can remarry. They permit her to remarry. Let's say she goes. Now, even though she is permitted to remarry, let's say she goes and she sleeps with some guy without marriage. Kilkela. She acts in a promiscuous way. And then it turns out that her husband actually was alive. He comes back. So this is an act of adultery. Now, she didn't know. So it's bishogeg. But who is liable? She is liable. Chayevet bekorban. Why is she liable? Because the Bet Din only permitted her to go and get married. If she would go and get married, and the Bet Din made a mistake. Oh, what am I supposed to do? I relied on Bet Din. Okay, then that would be an issue of Horayot. The Bet Din is responsible. She's not responsible. But in this case, the Bet Din says, listen, we gave you a permission to go ahead and get married properly. But you took our permission and you went and you just slept with a guy. We never gave you permission to do that, and therefore we don't have to take responsibility for that. You bring your own korban in that case. What you see here, it's a case where the Bet Din gave a practical ruling, a halacha lema'aseh. They told her specifically, you can go and get remarried. And that is a case of where, because she did the wrong thing, she's liable. But if she went and followed their advice, because they gave halacha lema'aseh, then they would be liable. Amar Ravina, af ana name tenena, horu Bet Din la'avod al achat mikol misvot hamorot b'Torah tu lamidi. Ravina says, I have a proof from our Mishnah that over here in Masechet Horayot, where it says, if the Bet Din horu, that means they gave a practical ruling regarding one of the mitzvot in the Torah. So from this word horu, you see that this law only applies if they give a halacha lema'aseh and no further proofs are needed. Another version of this whole discussion that we had, and here the opinions of Shmuel and of Dimi are going to be swapped. It's Shmuel that says that a court is only liable if they gave a practical halachic ruling, halacha lema'aseh. Rav Dimi says, even if they didn't say la'asot, if they just said mutarim atem, we consider that a complete ruling, and if the people follow it, then the Bet Din is liable to bring a korban. Amar Abaye v'ha tenan hachi chazar li'iro v'shana olimed keder shelimed patur hora la'asot chayav. And now each of the three proofs that we had in the first version are going to be brought here as challenges. So Abaye says, Rav Dimi, how can you say that? We have a Mishnah in Masechet Sanhedrin regarding Zaken Mamre, that if he hears a ruling from the Sanhedrin and he goes back to the city, his own city, and he teaches theoretically, that's okay. But if he teaches a practical ruling, then he is liable. And so there's a parallel between these laws, and just like the Zaken Mamre will be liable only if he says Hora, halacha l'maaseh, so too, the members of the Bet Din who give a mistaken ruling should only be liable if they say halacha l'maaseh. That would be a proof for Shemuel and a challenge to Rav Dimi. Amar Rabbi Abba, va'lo tenan hachi, horu la Bet Din lihinaseh, v'alcha v'kilkela chayvet bekorban, shelo yotiru la ela lihinaseh. Rabbi Abba says, I have a challenge against Rav Dimi from the Mishnah in Masechet Yevamot, that when the woman's husband goes away and there's some testimony that he died, and the Bet Din says, okay, you can go and marry, and she, instead of going and getting properly married, she goes and sins with some guy, and then the husband comes back, turns out it was adultery, she has to bring a korban because the Bet Din did not permit her to go and be promiscuous. They only permitted her to be married. But that means if she did go and was properly married, as the Bet Din said, then she would not be liable to bring a korban. The Bet Din would. But you see here, it's an example of them giving a practical ruling to this woman. Yes, you go ahead and marry. Amar Ravina v'halo tenan hachi horu Bet Din lavod al achat mikol misvot hamorot b'Torah tu lamidi. Ravina says, I have another challenge against Rav Dimi from our Mishnah, where it says if a Bet Din horu, they gave a practical ruling to go against one of the misvot of the Torah, then they are liable. From the fact that it says horu, it means they have to say the word, in fact, la'asot, to lamidi, and there's no further challenges that we need against Rav Dimi. Ve'halach hayachid ve'asa shogeg al pihem. The Mishnah teaches that if an individual would go ahead and follow a law by mistake based on the words of the Bet Din that ruled that a certain thing is kosher even if it was not kosher. V'nitneh ve'asa al pihem shogeg lamali. Question about the verbose wording of the Mishnah. Why does it have to say shogeg and al pihem? Just say that this individual went and followed what the Bet Din said. Why do you have to say by mistake? Amar Rava shogeg la tu yehoru Bet Din shecheleb mutar v'nitchalef lo cheleb b'shuman v'achalo patur al pihem mamash. Rava explains that the word shogeg is coming to include yet another case where the individual would not have to bring his own korban. And that's when the Bet Din said that this certain piece of fat is permitted. In fact, it really is cheleb in reality. And they mistakenly ruled that it's permitted. Now, this individual, he was planning to eat a kosher piece of meat. He had two pieces of meat in front of him, one kosher and one chelev that the Bet Din ruled was permitted. But he wasn't planning on eating that one, so he wasn't directly relying on the permission of the Bet Din. What happened? He was planning to eat the kosher one, and they got switched, and by mistake, he ate the one that was actually chelev. And so here you might think that he would be liable because he actually ate it based on his own mistake, not because he was planning on following the opinion of the Bet Din. Nevertheless, this word shogeg comes to include this case, that also the individual is patur, does not have to bring a korban hatat, because even though he wasn't planning on eating that piece, but it happens to be that this piece of meat, the Bet Din said, is permitted, and so he doesn't have to bring a korban. And then the words al pihem comes to teach al pihem mamash, a regular case where the Bet Din says this thing is kosher, and he says, oh, it's kosher, and then he eats it, totally based on their ruling without any other misunderstanding. There's another version of Rava's statement that's completely the opposite, where Rava says, shogeg. What does it mean, shogeg? Shogeg al pihem. If he made a mistake precisely because of their words, that they said this is kosher, and he ate it because they said so. That's when he is patur, when he was relying only on their ruling, and there was no other mistake involved. However, if he was not planning on eating that piece, he was planning on eating a kosher piece of meat, and he got messed up, and he ate that piece by mistake. He switched chalev with shuman. Chelev is prohibited fat. Shuman is kosher fat that he was planning to eat, and instead he ate the chelev. So this mistake was because of his own mistake, because they got switched, not based on their ruling. And if he eats that, then the individual is liable. And so that's the complete opposite version of this interpretation of the word shogeg, also in the name of Rava. Another presentation of the same ideas. This law that was known, obvious to Rava, although it's not obvious which way he went, but whichever one it was, Rava knew that law. He had an answer to it. Was actually brought up as a question from Rami Bar Chama. Rami Bar Chama. What if the Bet Din said that this particular piece of chelev, they ruled mistakenly that is permitted, and then someone came and ate it thinking that it was a kosher piece of meat, meaning there was two pieces of meat, a kosher one and this other one that the Bet Din ruled about. He wasn't planning on eating the one that the Bet Din ruled about. He was planning on eating the kosher one, same case as before, but they got switched, so he ended up eating the one they wasn't planning on eating. What's the law? He asked that question, and Rava responded to that. Amar Rava, Tashma halach v'yachid v'achsa shogeg al pihem v'chule, shogeg al pihem lamali, lav latui haru betin shecheleb mutar v'intchalef lo cheleb b'shuman v'achalo patur, Dilma shogeg al pihem hu de patur, avad nitchalef lo cheleb b'shuman v'achalo chayav. Rava says, I'll give you a proof from the Mishnah, where it says, if an individual went and followed their ruling by mistake, ruling shogeg al pihem. Why do you need all those words? Is it not to come to include this very case where the Bet Din said that this piece of chelev is permitted, and then he is switched and he wasn't planning on eating that particular piece of meat? So isn't that this word shogeg coming to teach us that he's patur? So that's what Rava said at first. But then the Gemara says, well, maybe not. It could be that the word shogeg al pihem is being particular. Only if he made a mistake precisely because of their words, and he was planning to eat this meat that they ruled about. But if he switched them, then chayav. So Rava is answering, but he gives one answer, but then the Gemara says maybe the other way around. Another version of this whole thing. Amar Rava, Tashema, halach yachid v'asa shogeg al pihem, ma'alav shogeg al pihem hu de patur, avon chalef lo b'chele b'shuman v'achalo chayav, dilma o shogeg o al pihem. Another version of Rava's answer to Rami Bar Chama, Rava says that, we can learn it from our Mishnah, because it says if an individual goes and eats shogeg al pihem. So isn't that all one case? What does that mean? Shogeg al pihem, only if he makes a mistake based on their words, then he's patur. But if it's a mistake based on, because he switched chelev and shuman, and ate it, then it's his own mistake, and chayav. So isn't that a good answer to the question? And the Gemara says, no, maybe not. Maybe when it says shogeg al pihem, it's not all one case, but or shogeg or al pihem is two cases. Al pihem is the regular case of following their ruling, and their ruling was mistaken. And shogeg is this case where they made a ruling about something, but he's also switched around what they were. So he wasn't planning on relying on that ruling. And so maybe that case also is a separate case, or shogeg or al pihem, and therefore will be patur. And so what we end up having is a number of versions of the same reasoning. Rava first argues for patur, then argues for chayav, and then we say maybe it was a question from Bar Chama, and Rava answered it, if he answered it one way, but then we can argue the other way, or he answered it the other way, and then we could argue back the previous way. Now the Gemara notes that these two possibilities, that in this case when you switch them, it could be chayav or it could be shogeg, and we had two different versions of what Rava said, is actually a machloket between two other Amoraim from Eretz Yisrael. Haru betin shecheleb mutar v'intchalef lo cheleb b'shuman v'chalo. Rav amar patur v'Rabbi Yochanan amar chayav. Betin said that this certain cheleb is permitted, and a man had two pieces of cheleb. That piece that they said is permitted, but it actually is cheleb, and another piece that's permitted. He was planning on eating the permitted piece, but by mistake he took the one that actually was cheleb and ate it. Rav said he does not have to bring his own korban, because in any case the Bet Din said that it's permitted. And so he could say, I'm relying on the Bet Din. He wasn't actually relying directly on the Bet Din, but even if he knew what he was eating, he would still have thought that it's permitted. And Rabbi Yochanan said he is liable because he made his own mistake, besides the fact that the Bet Din made a mistake. So he's not relying solely on the Bet Din. Me'tibeh. We have a challenge against Rabbi Yochanan. Me'am ha'aris ba'asota prat lemishumad. Barata teaches that this is later on in the chapter when it talks about a korban chatat for an individual, and says, for if an individual among the common people shall sin, and one of the mitzvot, and that phrase is me'am ha'aris ba'asota. So me'am ha'aris, that mem is exclusionary, meaning that doesn't include everybody of the people, but only some people bring a korban. Who doesn't bring a korban? That is a mishumad, an apostate. Someone who sins all the time. He doesn't care. So in that person, even if he eats something by mistake, he didn't know it was chelev and he ate it, but he would eat anyway because he eats non-kosher. He doesn't care. So that person cannot bring a korban chatat because that's only for someone who otherwise would not want to sin. And this guy doesn't care about sinning. So it's basically almost like he is doing it b'mezid. Happens to be he didn't know about this one, but he would sin b'mezid. So he cannot bring a korban, and that we learn from the letter mem. Rabbi Shimon ben Yoseh omer mishum Rabbi Shimon. However, this Rabbi Shimon says, I agree with the law, but I have a different derivation. And no sarich, I don't have to learn it from the mem. Harehu omer, asher lo te'asena, bishkaga ve'ashem o hoda. Hasham midi'ato, mebi korban al shigato. Lo sham midi'ato, eno mebi korban al shigato. Right there in that pasuk. And the next one, it says, if an individual does a sin that is not allowed to be done, meaning lo ta'aseh, bishkaga, and do it by mistake, and he is guilty, or hodat, and it's known to him. So, meaning when he sinned by mistake, he didn't realize that this was prohibited, or prohibited item, and then he finds out, so then he brings a korban. We learn from this, or hodat, that if he comes and makes teshuvah, once he has awareness, then he brings a korban because he didn't know and he sinned by mistake. But let's say he would not make teshuvah had he known, then he does not bring a korban, and therefore a mishumad is part of this category. It happens to be he didn't know that this was chelev. But even if when he finds out, that's chelib, doesn't make teshuvah, he still would have eaten it. So therefore he does not bring a korban for that mistake. And so I don't have to learn it from me'am ha'aretz. I can learn it from this phrase, o hoda. Okay, now knowing that, here's going to be the question against Rabbi Yochanan. V'im ita, if, according to you, Rabbi Yochanan, one is liable to bring a korban, even though he switched them and he didn't even realize, but this case should be the same as the apostate, because this guy was otherwise an observant Jew, and he thought he was taking the kosher meat. Instead, he took the other one that the Beit Din said that it is kosher, even though it was really chelib. Now, when you go and tell this guy, you didn't realize you didn't take the one that you knew was kosher, you took the other one that the Beit Din said was kosher. Well, when you tell him that, his reaction will be, but that other one, the Beit Din said that's kosher. It wasn't the one I was planning on eating. It's true, I made a mistake, but this one is also kosher, so he would not make teshubah. Not because he's a bad guy, because he would rely on the Beit Din had he known that was the one that he ate. And since he is not going to make teshuvah once he knows that he's in the same category of hoda, only if he makes teshuvah that when he knows, then he brings a korban. Otherwise, doesn't bring a korban. This guy also should not bring a korban. So Rabbi Yochanan, how could you say that he does have to bring a korban? Amar Papa Kasabar Rabbi Yochanan, kevan dechi mit yeda lehu lebe dina. The Papa explains that Rabbi Yochanan could answer that since when this individual realizes that he actually ate the wrong one, and when the Beit Din also realizes that they made a mistake, so both of those realizations together, the Beit Din will tell people, we made a mistake, that thing that we said was kosher is actually chelib. And this guy will realize that he ate the wrong one and he ate cheleb. So then he will make teshubah. So because he will make teshubah, when he finds out both of those errors occurred, then he will make teshubah. So then he has to bring an individual korban. That's a good answer for Rabbi Yochanan. Amar Rava. Modeh Rav she'eno mashlim lerov sibur. Ma'itama amar kera bishkaga ad shu kolam bishkaga achat. Rava says, even though this individual does not bring a korban, the individual who switched the pieces and ate the one that he tried to eat the one that was kosher and ended up eating the one that the Beit Din said is not kosher. So even though he does not bring an individual korban according to Rav, Rav agrees that that individual is not included when you count towards a majority. In order for the Beit Din to have to bring a korban, this par, they only bring it if the majority of the community followed their ruling. If they gave a false ruling and only a few people followed it, they don't bring korban. Only if it's a majority. Now, so you have to count the majority. You have to see, is it 51% of the people? Now, when you count the people that directly followed the Beit Din's ruling mistakenly. But this guy, who wasn't planning on following the Beit Din's rule mistakenly, he was planning on eating the other one, does not count towards this majority. Why? Because the pasuk says bishkaga, if the community does it by mistake, and that means if they all do it with the same type of mistake, all meaning all for the same reason, they all thought that the Beit Din said so, that it's kosher, and they all eat it for the same reason, because the Beit Din said so, and not because they made a different mistake that they thought they were trying to eat someone else. Ben if you remember, the Mishnah brings three cases, whether they ate at the same time, or the judges ate the thing first, and then the individual did, or the individual ate it first, and then the judges did. Why do we need all these three cases? Just say, all of them. Just leave it out, and we could assume all cases. Why does it have to say each individual case? Aren't they all the same? So, Bishlama Resha lo zu af zo ketani. Well, we understand in the Resha, where he says the individual does not, because it's a regular individual, not a learned person, so the individual is patur. He does not bring his own korban. So there, it's saying not only this, but even that. Each one's bringing a bigger chidush, and it ends with the biggest chidush, that even if the judges did not sin at all, in this case, they did not eat the cheleb, and only the individual sinned, you might think in that case, well, the individual certainly should be liable, because only he's the one that sinned, and the judges didn't. Why should the judges have to bring a korban? And so even in that case, because they gave a ruling, the judges have to bring korban and not the individual. So that's lozu afsos, giving us a bigger chidush and a bigger chidush, which is a typical form in the Mishnah. But in the Sefa, where it's a learned person who knowing that the Beit Din made a mistake, still follows their ruling, in that case, the Beit Din is not liable and the individual is liable. In that case, it should go in the reverse direction if you wanted to give a bigger and bigger chidush. So we answer, Zo ve'en sarich lomar zo katani. No, in the Sefa, it's following the same order, but then there'll be a different principle that kicks in, which is, it's true in this case, and I don't even need to bother telling you in that case, because that case is even more obvious. Now, there says two examples in the Sefa. If one of the judges themselves knows that is a mistaken ruling and follows it anyway, or a Talmid who is worthy of teaching. Now, why do I need both of these examples? Just give one of the examples. Amar Rava isterich. Salkadatech amina hanemile gamir v'sabir. Aval gamir v'la sabir la. Rava says I need both of them, because if I only had one of them, I would have thought that this is a stringency on the individual. If the individual is learned and knows better, then he has to not follow this. The Beit Din said this is cheleb, but he knows Beit Din said it's kosher, but he knows that it's cheleb. So then he cannot follow it. He's liable if he does. So if I only had one of these examples, I would have thought this only applies to a person who's learned in two ways. Gamir means he knows everything by heart. He learned the oral law by heart. Savir is if he has analytical skills. He can derive one thing from the other. Only if he has both of these, this goes in order. When students were young, they would learn everything by heart, and then savir, that they could figure things out on their own. If he had both of these, then he is responsible for his own actions. But if he is learned in that he knows everything by heart, but does not yet have analytical skills, maybe I would think that he's judged as a regular individual and he would be patur if I only had one of these. And that's why it says both of these examples to teach me that both the gamir v'sabir, and even someone who's just gamir, that's sufficient to know. If you know everything by heart, then that's sufficient knowledge that you are responsible for your own decisions, and you can't just rely on the Beit Din. Amar le Abaye, lehora'a gamir v'savir mashma. Abaye says, wait, how can you learn that? After all, it says the word lehora'a, otamid v'ra'ui lehora'a. So hora'a means that he can give rulings. In order to give rulings, he has to not only know things by heart, he has to be able to learn to compare one thing to the other. Otherwise, you can't give rulings on a case if you can't compare the rulings to see if this applies or that applies. So how can you read that in? Rava says, here's what I meant to say. If I only had one of these examples, that if the judge himself knew that they were wrong, and I only had that and not the Talmid, that's Ra'ul Hora'ah, then I would think, yes, indeed, only someone who is Gamir v'Sabir, he has to know better and he's liable for his own actions. But if he's only Gamir and not Sabir, then not. That's if it only had the judge. But, so therefore, we go the Tana ra'ui lehora'a memishnah yetera afilu gamir v'lo sabir v'lo gamir. That's what Tana says. And also a student who is worthy of giving rulings. This is in fact redundant. So why is the Mishnah saying another case that's the same thing? Oh, from that redundancy, from those extra words, we can learn not only someone who's gamir v'lo sabir, but also sabir v'lo gamir. Not only if he is knowledgeable but doesn't have analytical skills, also if he has analytical skills but not knowledge, one or the other would be sufficient to make it that he is responsible for his own decisions and he has to know better, and therefore he would be liable if he follows the ruling of the Bet Din. What's interesting here is that the Gemara is treating the Mishnah almost like a pasuk, like an extra word in a pasuk comes to teach you a new law, that we're doing the same thing in the Mishnah. It in fact says the same thing twice. So from the extra thing, we can learn that this is true yet for another category. Ra'oi lehora'ah. Now we go back to the phrase in the Mishnah that says a student who is worthy of issuing rulings, and we ask Kegon man. Like whom? Who would be on that level that we would say, oh, that's a student that can issue rulings? Amar Rava kegon Shimon ben Azai v'Shimon ben Zoma. Rava says it would be someone on the level of Shimon ben Azai and Shimon ben Zoma, who are on very high level. These are very outstanding Torah scholars. So that's the level of someone that you have to be on in order that you should know better. And this person cannot rely on the Bet Din, but they would have to know themselves. And if they do rely on the Bet Din, then they would have to bring a korban themselves. Amar le Abaye ki hai gavna mezidu. Abaye says, no, these two sages are so knowledgeable, if they would go follow the ruling of the Bet Din, knowing that the Bet Din is wrong, the Bet Din said, this is kosher, but they know for sure it's chelev. They're such great rabbis that if they followed their own ruling, that would be sinning intentionally. They know 100%, and they're going to follow it anyway. They wouldn't be able to bring a korban chatat for themselves. They would be b'mezid. And so that can't be that they're on that level of knowledge. It has to be something lower, that they're somewhat knowledgeable, but not so knowledgeable that would be like 100% sure in mezid. Have to be someone that would have a serious suspicion that the Bet Din was wrong, but not so learned that you could call him mezid. We need someone that's like a lower level. That would be b'shogeg. Rava answered Abaye, oh look, I have a baraita to back me up, because it says here, Ba'asota achat, if someone violates one of the mitzvot, our case of the Bet Din giving and issuing a false ruling regarding some law that is a law ta'aseh, for which you are liable to a chatat, yachida osem piatzmo chayav horat Bet Din patur. The baraita teaches the general rule that if an individual sins on his own account, not relying on the Bet Din, he's liable. But if he sins based on the ruling of the Bet Din, then he's not liable. Kesad was an example. Haru Bet Din shecheleb mutar v'noda lechad mehen sheta'u. O tamid yoshev lifnehen v'ra'u lo hara'a kegon Shimon ben Azai. Yachol yeh patur tomadoma ba'asota achat. Yachid ase al pihen, al pi atzmo, chayav. Barat Bet Din patur. So it gives an example of a Bet Din that says, this piece of cheleb here, they mistakenly ruled as permitted. And one of the judges themselves realizes that this is a mistaken ruling, or a student that sits before them, but that student is so advanced, he's worthy to teach and give halacha himself, like Shimon ben Azai. You see, the Baraita here itself gives the example of Shimon ben Azai. Rava just added another example of Shimon ben Zoma. And continues and says, could it be that a student on that level could rely on the Bet Din and be patur? No, that's why it says ba'asota achat, when he does a sin based on the Bet Din. And so we end with the general rule: an individual who follows his own understanding and sins anyway, and he knows better, that he's liable. That would be like Shimon ben Azai. If he's not so knowledgeable and he relies on the ruling of the Bet Din, only then is that individual patur. So how are you going to explain this baraita? You have to explain it too. What would be the case? It has to be a case where this great sage, he knows that this is prohibited, that this is in fact cheleb. What's his mistake? How come he's not called b'mezid? He made a mistake regarding the law that you have to follow the rabbis. There is a law that you have to follow the rabbis, and he thought that you have to follow the rabbis even when you know that they made a mistake. So that's why he followed them. So in fact, he did make a mistake. He knew, because he's such a great sage, he knew that this is in fact cheleb. But he thought that, you're supposed to follow the sages, the majority, even when they make a mistake like this. That kind of mistake about the meta rule, that's possible that even a great sage could make. And so Rava answers, when I gave the examples of Ben Azai and Ben Zoma, I meant precisely this type of example when he made a mistake regarding the meta rule, that one, he thought that he should follow the words of Chachamim no matter what. But in fact, the law is that an individual who knows better cannot rely on the false ruling of the Bet Din. Our Mishnah ended with a generality, and this is the general rule. If you are sinning based on your own knowledge and you know better, then you're liable. What is this coming to include? You already said this in the Mishnah in the examples that you brought. Why do you have to give a general rule at the end? This is coming to include someone who hates the rabbinic rulings. In general, he follows his own opinion and doesn't rely on what the majority of the rabbis say. If this is the kind of person who generally doesn't follow what the rabbis say, and then in this particular case, he follows what the rabbis say, he is liable, because even though in this particular case he didn't realize that the ruling of the Sanhedrin is wrong, he thought that they were right. But since in general he never follows their ruling, he doesn't consider them to be authoritative, and so he cannot now all of a sudden for this law say, I was following what they say. No, you never care about what they say, so you can't get out of your liability for this. That individual has to bring a korban, even though in this particular case he didn't know better. Now, the general rule at the end says also, if someone relies on Bet Din, a regular individual doesn't know better. Why do you have to include this general ruling? We already had this in the examples. This comes to include if the Bet Din gave a ruling, and then they realized that they gave a ruling and they changed their minds. And this individual didn't hear the update that they changed their minds and said, actually this is cheleb, this is not kosher, and he ate it. That person is included and is also patur because he didn't get the message. We ask, wait, this example is going to be mentioned in the very next Mishnah explicitly. So why do you need a general ruling here to tell me something that's explicit in the next Mishnah? And the answer is Taneh v'hadad mefaresh. Sometimes the Mishnah does this. It says something in a general way, and then later on it explains it further. And that's the structure, the style of the Mishnah here, to give the general rule, and it will explain further in the next Mishnah coming up soon. The next sugya is going to go on further all the way into the next daf, so we can begin this sugya tomorrow. Baruch Adonai le'olam, amen ve'amen.